How can you really know where something was made, or even what it's made of? It's easy to tell with real-life things, but what about the content on our screens? Now more than ever, verified authenticity is critical, especially with the advent of AI. That's why a global community, including companies, organizations, and civic leaders, have come together in the Content Authenticity Initiative. The movement's goal is to promote universal adoption of content credentials, the open standard for content authenticity and provenance that can be attached to images, video and audio files, documents, and more. Think of it as a digital nutrition label. Camera and software companies are already including it in their products. You can choose to embed content credentials in your files and make it clear for people to review. You can interact with this icon to see the origin and edit history of the file. Content credentials can be stored in the cloud for added durability. The underlying technology implements the C2PA open standard, and the Content Authenticity Initiative is helping make it more widespread with free open source tools. On top of that, we're working with educators, policymakers, creators, and the industry to speed up the adoption of content transparency. Together, we can create a world with trust and transparency built into what we create, share, and see online.
Hello, everyone. It's always so great to see everyone writing in from all around the world for these events. Welcome to our conversation on authenticity in courtroom evidence. My name is Jen Tse, and I'm the community manager at the Content Authenticity Initiative. And as you saw from that intro video, our work at the CAI is about accelerating the adoption and implementation of the open C2PA standard of content credentials. It's that digital nutrition label that tells you the provenance of a piece of content. For example, where it came from, what device was used to create it, whether or not any edits were made to it, whether it was generated with AI, and so on. At the CAI, we work across the content lifecycle, from content creation to editing to publishing. And we've made significant progress in accelerating implementation across all of those areas. Camera and mobile phone companies are implementing the standard to establish the chain of provenance at the moment that a photo is taken. We've supported the integration of this technology into Adobe and non-Adobe software, since it is an open source specification, to record any edits that were made to files and to allow creators to add their attribution information to their work and to protect their work. We've seen Gen AI models add content credentials to their outputs by default. And we're seeing more implementation further downstream in publishing in content delivery networks, content management systems, and social media. In our work advocating for this open source standard developed by the C2PA and elevating the successes of implementers across sectors and around the world, we've had the opportunity to highlight applications of content credentials in journalism, in government, in the creative industry, in advertising, and in other realms. But we haven't yet had the chance to spotlight another really important and really consequential use case in the legal system and in the media evidence that can be presented in a court of law. AI content is already impacting how justice is delivered. And I'll show you a quick example right here. Just in May of this year, the family of a shooting victim used an AI-generated victim impact statement at the sentencing hearing for his killer. It shows the deceased appearing to forgive the man who shot him from beyond the grave. And based on this video, the judge lowered the sentencing from the maximum sentence to 10.5 years for manslaughter. Now, AI wasn't used as evidence in this instance, and so it didn't affect evidentiary integrity. But if AI can be so convincing that it can now affect the degree of punishment or the degree of consequence after a conviction, maybe it's not such a huge leap to think that it could impact legal proceedings before the verdict. And as AI models become even more advanced, this can introduce a lot of confusion and complexity in trial where the stakes can be really high. I'm really looking forward to digging into this today with our expert guests. But before we get started, you'll see a Q&A window at the bottom of your screen. So over the course of this next hour, if you have any questions for our guests, feel free to drop them into that window and we'll save some time at the end of our conversation to address them. Joining me first will be Jan Norman, Assistant District Attorney at the Davidson County District Attorney's Office in Nashville. Let's welcome Jan up to the stage. Hello, Jan. Thank you for joining me. Thank you so much for being here. I'm really excited to have you on.
Absolutely. Thank you for having me.
So, Jan, you've been prosecuting homicides and violent cases for 16 years, and you specialize in digital evidence. Can you tell us a bit about how that became your specialization?
Sure. I began as an assistant district attorney, and when I was assigned my first homicide case, the case involved 5 separate suspects. We had call detail records with cell tower location data for all of those suspects, but that was not something that was being admitted as evidence on a regular basis in our courts. And so I worked with people with the Technical Services Unit at the TBI, and also with some of our forensic examiners in the police department to basically craft what that testimony would look like so that we could have expert testimony about location data as it included the networks, because at the time that was the new thing back then. Since I was involved in that case and started working with all of those people, it just kind of naturally that I began to handle cases that had somewhat more complex digital evidence, specifically anything that is derived from the cell phone extraction, so mobile forensics, as well as call detail records, but anything that relates to location data is something that I was particularly interested in. So I've attended numerous trainings and have worked with some amazing people on that specific type of evidence.
You've done some amazing work as well. For those of us without a legal background, can you tell us what the standard of proof is for criminal cases and who has the burden of proof?
So the burden of proof in a criminal case is that we have to prove the essential elements of the criminal offense charged beyond a reasonable doubt. A reasonable doubt does not have, there's no number that you can put to it. It is not an absolute certainty. Absolute certainty is not required. It is a moral certainty. So the law is, after you have reviewed all of the evidence, it's whether or not the mind can rest easily as to the certainty of guilt, which that is very specific in the law, that we only have to prove the elements of the offense beyond a reasonable doubt. Anytime that you have a criminal offense, motive is never an essential element. We don't have to prove motive in order to obtain a conviction. So if you think about it, if for a first degree murder, there are only 3 elements: is that the victim was unlawfully killed, that the person acted intentionally, and they acted with premeditation. So those are the only 3 things that we would have to prove beyond a reasonable doubt.
Mm-hmm. As you've mentioned, the standard involves moving beyond doubt on those 3 elements. However, AI models have now become so sophisticated that they introduce significant doubt to our understanding of digital media. Let's take a look at this example from the recent release of Sora 2, OpenAI's newest text-to-video generator, and I'll share that on screen right now. So this video, it's an AI-generated video, of course, and it shows fake CCTV footage of OpenAI CEO Sam Altman shoplifting at a Target. It was actually created by OpenAI's own developer for Sora, Gabriel Peterson.
Please, I really need this for Sora inference. This video is too good.
So obviously, this video wasn't made with the attempt to deceive, and Sora 2 is actually one of the models that automatically attaches content credentials to all outputs. So fortunately, there is a way for people to see that this was AI generated. But I wanted to draw your attention to the subheadline at the beginning of this article. Every defense attorney now has a pre-written motion when it comes to video evidence because of how sophisticated these AI models are. Can you speak about how defense attorneys can use doubt about image or video origins to discredit evidence that is real, or otherwise use doubt as a strategy in court?
So I want to be very clear that when it comes to reasonable doubt, that is to the essential elements of the charged offense. There is a different kind of assessment that is done if you're talking about a photograph or a video. That's just going to be admitted. And so you're talking about the authentication process. And there is no standard of it has to meet this definition when it comes to authentication. It's very specific that it doesn't require any certain proof, only enough proof. And so you're not going to have something where content credentialing is going to make something automatically admissible. That's not how the law works. When you're looking at admissibility, it's whether or not you have actual facts that go with that piece of evidence. So for your example that you used, there's going to be a loss prevention person at Target that's going to say that video did not come from him. You're always going to have facts and witness that are going to relate to any video or photograph. So a defense attorney can file a motion. They file motions all the time. It does not mean that that piece of evidence is not going to be admissible. If there are questions about whether or not it was altered, then that is something that goes to the weight that the jury gives that piece of evidence. So the jury can consider whether or not they think it's authentic, but there's very few times where an image is not going to be admissible if it is relevant to the facts of that case.
Mm-hmm. But ultimately, it will come down to the jury's perception, if I'm understanding.
Well, I mean, in any criminal trial, obviously, if it's in front of a jury, then yes, everything comes down to a jury. They can choose to accept something anytime they can present it to them. It doesn't have to be a video or a photograph. But this is not something where it is going to prevent evidence from being submitted. You submit the evidence and then you have witnesses that are going to testify kind of on both sides. If the defense wants to bring in an expert to try to attack the authentication of a piece of evidence, that's just a testimony for the jury to consider.
Mm-hmm.
Does that make sense?
Yeah. Have you ever had defense attorneys attempt to submit evidence that was manipulated? And if so, what was the response?
Well, I have not personally had that in one of my cases, but our office has had instances where they have created a text message thread and tried to submit just a screenshot without any actual evidentiary basis that the messages were between two specific users. That was not permitted because they couldn't give that basic foundation of authenticating where it came from. There was another case office where a defense attorney, they actually did submit a photograph where they had changed the location data and the metadata, and they submitted it in a Celebrate report. And so that was an instance where our forensic examiners came in and testified to explain how that could be done, and that it did not mean that that person was at that location, which of course the defense did not provide that device, so we did not have a forensic examination of it, so that our experts can say more, but that was done recently in one of our courts.
Mm-hmm. Can you tell us more about how, as a prosecutor, you go about authenticating the origins of photos and video and audio that end up becoming evidence used in court?
Absolutely. So anytime that there's a photograph or a video, one of the reasons why there's never going to be some kind of magic bullet, this makes it automatically admissible, is because everything comes down to the facts and circumstances of the case. we're never convicting anyone over a single photograph or a single video. It is always something that is in conjunction with all of the other facts and circumstances in the case. So each and every picture, I mean, you can have a video posted to YouTube. You don't know who took it. You don't know when they took it. You don't know who posted it. But if you have a witness that can identify the person in that video and can explain the relevance to the criminal case, it is going to be admitted, because you don't have to have kind of a magic person or a magic piece of evidence. It's all contextual to the circumstances of that particular case.
Mm-hmm. According to experts in deepfake detection that we work with at the CAI, even the very best detection services available are only correct 80 to 90% of the time. And so there is a large percentage of media that is incorrectly determined to be AI or incorrectly determined to be genuine. Is it enough that even the experts that prosecutors rely on can't be 100% sure?
Okay, I feel like you just said that there was a large percentage of media that was incorrectly determined to be AI. Is that what you said?
Yeah, the detection services available are only correct 80 to 90% of the time. And so a lot of it is incorrectly determined to be AI or incorrectly determined to be genuine.
Okay, I don't have any basis of knowledge if that is true. I think that any time that you have a forensic examiner, there's always a chance of circumstances possibly existing, but your forensic examiner is going to be trained. They have a ton of experience in practical application, and they are going to be able to explain whether or not that would even be likely in this area. That's why you don't take one piece of information, but you're looking at the totality of it. Many times when we're looking at digital evidence, the biggest thing is to prove that the suspect is the person using the device at the time whatever was created on the device. So you have to look at the actual facts and circumstances, look at the messages that were being sent. You have to look at everything related to that image. And again, I think there's technically probably going to be a possibility, but it's whether or not that would be likely. Does that make sense?
Is there a specific case that you've prosecuted that has had a lasting impact on you? And how did the availability and the trustworthiness of digital evidence play a role in securing a conviction?
I've had many cases, but one that stands out particularly kind of was known locally as the Vanderbilt rape case. It was a rape of a Vanderbilt student where there were several defendants that were raping her while she was unconscious. It was a case that we almost did not ever have the chance to prosecute. They almost got away with it. They took videos of the rape on their cell phones, took pictures. They sent them to other friends that lived in other states. And then the suspects knew that they were under investigation, and of every single cell phone that was used to take those videos, they purchased software to wipe the computers of the friends that received them on their computer. And it was only because one of the friends, the software that was supposed to wipe his computer, it error messaged out, and he had canceled because he didn't want to lose his playlist, and he wasn't certain backed up. And if he had not done that, it would have changed the entirety of whether or not we were able to prosecute that case. And it was very specific. We could tell that the cell phone was backed up to that laptop computer, and we had the videos from the laptop. We had them in two different formats where they were sent and then when they were received. But also in that case, there was surveillance video from the dorm room outside in the hallways, and it was motion detected, like most surveillance cameras. But we actually spent a lot of time with the defense questioning that surveillance video only because it was motion detected. And so certain cameras have certain sensitivities, other ones had different ones. But because there were gaps in certain parts of the video, that was something the defense harped on a lot. It didn't really make logically. But in the end, there's nothing that was putting those defendants in the video. It was them. We had witnesses that saw them in the hallways. So there's almost always going to be a human being, a person that is going to be able to let you know, was that image what I see in that video? And when you have someone there and present, then they are able to authenticate that for you and dispel the issue that anything was fabricated.
Mm-hmm. It's reassuring to hear the amount of rigor and the amount of digital, or the amount of corroborating evidence that you need around each piece of digital evidence that is required to help authenticate or to help move beyond reasonable doubt. Thank you so much, Jen. It's been great having you on. Fantastic to hear from you. I'd like to invite our next guest up to the stage. Joining me now will be Brandon Epstein. Brandon is a technical forensics specialist at Magnet Forensics and also the chair of the scientific working group on digital evidence. Welcome, Brandon. Thank you so much for joining us.
Hey, Jen, thanks for having me.
And just for brevity's sake, going forward, I'll refer to the scientific working group on digital evidence as SWIGDE for short.
And that's bonus points for pronouncing SWIGDE correctly. There's about 75,000 pronunciations of them, but that's the right one.
Perfect. So could you briefly describe what SWIGDE is, what its mission is, its structure, and how it influences standards and practices in digital forensics and multimedia evidence?
Yeah, sure. SWIGDE is a voluntary consensus-based standards development organization comprised of state, federal, and local government examiners, as well as private examiners, people from academia, people from legal professionals, and any interested party that is interested in how to develop the best practices and ways we should present or acquire or analyze evidence in legal matters here, particularly in the United States. To break that down a little bit, as opposed to a lot of words in a sentence just there, SWIGDE is a practice standards development organization. So I see from a lot of the comments and questions that I really look forward to getting to toward the end here, that people are very familiar with C2PA as a technical standard of how to implement content credentials in a C2PA manifest within a video or image or audio file. Opposed to that, SWIGDE is a practice standard. So we talk about ways to best acquire digital evidence, or best handle digital evidence, or best analyze digital evidence. So these are the things that you should do. These are the things that you shouldn't do when you seize digital evidence, whether it be in a civil, criminal, or legal proceeding or investigation like that, whether you work for the prosecution or the defense on either side of that. And the purpose of this is to have a written set of guidelines or a yardstick to measure work by, because we want to make sure that only quality digital forensic services are produced and are introduced into the courtroom. So how do we do that? We get a lot of interested parties, much like the way that C2PA was developed. You get a lot of interested parties from a wide range of representation into a room together, and you write down that these are the way that things that should be done. So you get, again, both sides, prosecution, defense experts, you get academia, researchers, legal professionals, people from industry, all agree by consensus of this is the best way that you should copy data out of a cell phone, or this is the best way to authenticate a digital image for use in legal proceedings. And then that document then goes out for public comment. So anybody in the public, if any interested party, could then weigh in and say, I disagree with this, I think it should say that. And when all those comments are adjudicated, only then that becomes a published best practice or standard on the SWIGDE website that allows for reference material for those that are using this evidence, whether it be an examiner, investigator, or an attorney in courtroom for that reference.
Based on your background as a law enforcement officer and as a digital forensic examiner, what, in your view, are some of the biggest challenges to the integrity of digital evidence right now?
As we sit today, I will say deepfake number one, deepfake number two, deepfake number three as the top three, but not in the way you're likely thinking about it. So it isn't so much that we see an influx of manipulated media or deepfakes flooding into our courtrooms. What we see in my background as a digital forensic examiner, as well as someone that produces a media authentication platform and has researched in digital media authentication, and talking with our user base and within SWGDE and a lot of examiners, attorneys, and those that are working in the space, it is more the perception of the threat of digital of deepfakes opposed to actually the influx of deepfakes being implemented in our courtroom. What we see is the public perception. We see things like you just showed a few times, the Sora videos of Sam Altman shoplifting from Target. The perception of how easy it is to deepfake those videos. But the reality is because the public believes how easy it is, because our judges and our juries believe how easy it is, and because it really is that easy to manipulate evidence, to manipulate media, to manipulate images and videos, we have to flip the approach of the threat of deepfakes on its head. So I would say the threat really isn't necessarily deepfakes or synthetic media getting into our legal system. Right now, as it stands today in October 2025, the threat is proving authenticity, because many times when law enforcement or when private examiners, I've seen this on both sides. I give examples if you want me to expand a little bit on both sides of this. The issue is, how do I prove the evidence that I am trying to introduce into the courtroom is real, or is authentic, or is manipulated, or it has not been edited, or is not produced synthetically, when we see every day how easy it is to manipulate media? That's the current need right now. It's not deepfake detection, it's proving authenticity.
Mm-hmm. Can you describe how the chain of custody works for crime scene evidence? So what is the process of digital evidence collection and handling and analysis, all the way from when investigators arrive to the scene through to when that evidence appears in court?
Yeah, sure. Important question, right? And there's kind of two roads that we go down. I've seen this, and I saw people addressing this in the chat, and we've kind of touched upon both of these interchangeably, but I think it's two separate conversations here. The first of which is evidence that's produced by the person introducing it to court. So most often we think about this in a criminal case is that law enforcement goes out, they take photographs of a crime scene, excuse me, or they audio record or video record an interview, or there's body-worn camera footage. That's evidence that's produced with the intent of actually showing it as evidence in court. That's completely owned by the law enforcement agency or the person that is trying to introduce that in court. You can have many private investigators, private examiners, so on and so forth, working on both sides of the aisle that produce the same type of evidence. Now, when that case, it becomes about, and actually in both cases is showing that the evidence has not been changed from what we'll call cradle to grave, from its inception, from the time that, let's say I take a digital picture, it goes from light through a lens, hits a sensor, and it goes to ones and zeros on my SD card of my camera, that those ones and zeros are not changed by the time I take that picture all the way through to the point where I introduce that in court. Now, if it is changed, let's say I acquire or I export an hour-long CCTV video and I want to show 5 minutes of it in court, it wouldn't make sense for me to show the full hour, and often we'll trim that down to just a 5-minute video for the efficiency and ease of showing that in court. Or maybe I'll adjust a contrast in a photograph to make it easier for the jury to see in court. It's about identifying that original and accurately describing the steps that I took to that original to produce that final product. Now, that is for evidence that, let's say I took that crime scene photograph. The other pathway is evidence, I'll say, that comes in from the wild. And this is probably a little more concerning in today's age as we start acquiring evidence from victims, from witnesses, whether it be from cell phones, computers, CCTV cameras, IoT devices, vehicles, dash cams, whatever it may be that imagery comes from. Now we have, and that's why part of the thing that's with the address is how do we acquire that evidence in a manner that does not change it, and how do we show that it has not been changed from the way that it was originally acquired. That's where sound forensic principles come into play. And that's also where media authentication comes into play, especially when it is visual or images or videos with a threat, like I talked about, of synthetic media, is authenticating that at the point when it first comes into either into the police domain, whether it be a digital forensics lab, whether it be in a detective bureau, in a patrol car, on the side of the road, in an interview room. Is how do I build that trust in what is coming into I'm using the term me as the investigator to build that investigation or that examination on. And I will say it goes both ways. To touch on something really quickly, you spoke really quickly before about defense attorneys manipulating evidence and how to build trust in that. I've seen both sides of this. I've seen alibi videos from criminal defendants that were completely manipulated, completely fake to prove a false alibi, where media authentication techniques that were showed that specific manipulation to change, let's say, a date and time in a CCTV video. But I've also seen on the other side exonerating evidence come in the same way, or that exonerating alibi video come in where it might be implausible, especially, let's say, if there's eyewitness testimony, that the one piece of exonerating evidence comes in, and that media authentication, the proof of originality, the proof that it hasn't changed, is the key factor. And we see this time and time again. It's not talked about enough, where that actually exonerates innocent people from while legal proceedings are happening.
Yeah, having that, I guess, the digital counterpart to chain of custody, which is the CTPA standard, being able to record what happened to it, is so important. The CTPA standard isn't part of the guidance that SWGD has right now, but in the future, how could digital content provenance and the CTPA standard fit into what you create for digital evidence collection?
Look, I'll say this, that there's no silver bullet. There's no magic bullet to media authentication today, and I doubt there will be in the future. But there's going to be a lot of different approaches, combining sound forensic practice, things like content credentials within C2PA, other approaches, media authentication tools that are all needed to work to provide this chain of custody, this integrity, this authenticity to prove originality or identify manipulation along the way. It's not going to be that one day we flip a switch and we have the solution. It's going to take a wide variety of solutions. And as we start updating standards, especially within SWGD, because let's face it, digital evidence ever evolving. The things that we talk about today will change drastically. Technology will change drastically 6 months from now. And we need new technology to meet that. C2PA is one of those technologies that I could see being implemented in the future as it becomes more mature, becomes a wider adoption as one way, one data point amongst many other data points that really helps prove authenticity in court.
Yeah. And as a side note, I'll just take this opportunity to note that provenance technology and advocacy for that is not the only work that we do at the CAI. We also work with media literacy is a huge important part of our work, as well as our work with policy experts, so that keeping them informed as they create policy guardrails.
That's a great point. I mean, context to everything is so important, right? It is having an accurate understanding of where we are today, what we can say and what we can't say about media authenticity. I will say that we have a big literacy gap into understanding what we see online and we can legally authenticate in court. And much like the Sora video that was showed, that I was obviously a cell phone video screen recording of a CCTV image. I think that when we get down to it, that image that's posted online, let's say to X, Twitter, Facebook, Instagram, name the litany of them, I would not expect that to be able to be authenticated in a legal proceeding because of the things that happen online, because of things that change online when we start recording and sharing videos and posting them. I think sound forensic practice, if acquired in the right way, you could show one way or the other with a high degree of certainty, with demonstrable reliability, whether that was an original recording or not. but it requires that true forensic practice to do it. And building that context, that literacy for everybody, all interested parties, is so important.
Agreed. Well said. How are visual and audio forensics experts trained?
Well, there's a host of training out there. Excuse me. You have education. You have, I'll give a shout out to my alma mater, my grad school at the National Center for Media Forensics at the University of Colorado in Denver. There's other undergraduate programs in digital forensics. There's private organizations that, independent nonprofit organizations that will provide vendor neutral or just general foundational training about how media works or how to process media for use in legal proceedings. And there's also vendor training for the tools, like within Magnet Verify has specific training on how to use the tool, plus the underlying science underneath it to help examiners really provide reliable answers about media authenticity.
Mm-hmm. What advice would you give to law enforcement agencies or forensic labs that are trying to adopt policies or revise policies on digital evidence handling to align with SWGD's best practices?
Yeah, I'll give a shout out just for the SWGD best practices. They're written, they're available free online. I believe that the chat's, the link is dropped in the chat, that it's a great starting place to build SOPs. I started out as a police detective in New Jersey that started a one-person lab in New Brunswick, New Jersey. I had no resources. I had no idea where to go until I found the SWGD website to be able to say, all right, now I know the proper ways to do things, not because this is what I think it is because some really smart people from a wide range of areas came together and told me this is how I should be processing evidence.
Thank you so much, Brandon. We have to move on to our next guest. So thank you. Great to have you on. I'd like to invite my next guest up to the stage. We're going to have Geoff Lambright, the co-founder of Forensic Photonics. And Forensic Photonics have developed a C2PA-enabled device that scans latent fingerprints from crime scene evidence and then adds contact credentials to those images at the moment that they're taken. Welcome, Geoff. Thank you for joining me.
Thank you. Thanks for having me.
So for full transparency, for those of you watching the recording of this event, we experienced some technical issues during the actual event, and Geoff and I weren't able to have our conversation during the live event. So we're re-recording this now on a different day and adding it back to the original event recording. So Geoff, tell me about your background and your inspiration for the Lift device. What was the process like for you to develop it, to bring it to market?
Yeah, so my background is in physics, and most of my career was spent in microscopy, particularly in research in biology and neuroscience. And in those fields, I saw imaging technology kind of advance and overturn multiple times every few years. And I realized that a lot of that technology is not making it out of those fields and could be applied in other places. And at the same time, the area of forensics, I was troubled by one powerful statistic here in America, and that's that we're able to clear just barely more than half of our murders that happen here in America, meaning that we're able to solve just barely more than half of those and bring those to justice. And so nearly half of the murders in America are going unsolved. And I realized that there's an opportunity for new tools and new technologies to be developed to actually help address this issue. And so with my background in microscopy and understanding a lot of these techniques and tools that were developed in these specialized fields, I decided to kind of cherry pick some of these ideas and build this device, a fully integrated latent imaging fluorescent technology device for imaging latent fingerprints.
And what led you to implement the C2PA standard in the Lift device?
So we've looked at this as not just a camera, but a full process from digital evidence collection all the way to courtroom presentation. And so when we thought about that, we thought, okay, this device, we built this device to be fast, powerful, very easy to use, and an extremely good imaging device. However, if we think about it as a full solution, that's where we pull in the C2PA. So before my career in forensics tool development, I served on 3 different juries in San Francisco, and they were all criminal trials. One was a rape, one was an officer-involved shooting, and another was a homicide. In all 3 of those trials, I saw the defense attorneys, both public defenders and paid criminal defense attorneys, use the questionability of digital evidence manipulation to draw distrust and scrutiny on the entire process of the validity of the digital evidence. And to the point that it added days of extra deliberation, it risked coming to the proper decision because it distracted with irrelevant information away from the facts of the case, as opposed to actually focusing on the facts of the case. And it had a real impact on some of the jury members. And I realized that this is just what I'm seeing in the juries that I'm serving on. So I think there's a bigger effect here. So with that, I realized when I heard about C2PA, I realized this is the tool that can address a lot of that right off the bat. If you can have an embedded encrypted technology that any jury, any judge, anywhere in America can run through a check and say, okay, this is the original image that is verified to have come from this device on this date at this time, then you can eliminate a lot of that time spent and a lot of that unnecessary scrutiny and distraction away from the facts in the courtroom.
So not only does the C2PA standard help us eliminate doubt, but you're also saying it helps make the courtroom process more efficient and maybe even save costs.
Exactly. So in this particular application, it's not so much for the investigation itself, but that digital chain of custody and the verification of that digital chain of custody is what comes into play in the courtroom to simply answer the question, yes, this image came from that device. It wasn't altered. It wasn't made up. It's real.
Amazing. Let's take a quick look at the Lift device in action. Would you like to show us a demo?
My pleasure. So what I'll do is I'll just switch us over to the software so we can see directly the system in action. And what we can do, we're looking at a $10 bill that we have underneath the system. And I'm going to take 2 separate images. If we look, we can see that we have an enable C2PA signing option here. And right now we'll leave that unchecked. And I'm just going to click live imaging. And now we see the fluorescent labeled fingerprint. So we simply dusted the fingerprint with the fluorescent powder. This is the brush that I used. And now we're looking at the fluorescent fingerprint on the monitor. If I now say, let's snap an image, we do not have the C2PA enabled, but we get a grid of 9 images. This is what our software does. It allows the investigator to choose kind of a gamma adjusted image to see the lower intensity details of the fingerprint. So I can look at this one and say, okay, the middle one looks pretty good. And now I'm going to take a second image with the C2PA enabled so that we can compare the difference between the 2 images. So I'll say snap. We see the same grid of images appear. I'll choose the same image to save. And this time we see that the image is being signed. So the C2PA signing was in process. There's now an embedded encrypted hash that is verifiable through the C2PA authenticity tool. So now if I come to the folder where these are saved, we see the 2 images that we've saved. And I can also bring up the content authenticity inspect tool. First, I'm going to look at the image that we enabled the C2P signing on so that we can see what this looks like. So if I drag this over, we'll see some information appear. And we can see that the image was recorded by a Forensic Photonics device. And more specifically, we can look down here and we see the exact device that was used, and that we even see a serial number of that specific device. And of course, the capture date. So all this information is stored and protected here. If anything has changed on this image, this will no longer be verified. If a single pixel of information is changed on this image, this is no longer verifiable. Likewise, if we have an image where the C2PA was not enabled, such as the first image we took. Now, if we inspect this, we can see that as it looks for the content credentials, it will now tell us that there are no content credentials found because the C2PA was not enabled. So in this way, we're able to use the C2PA signing to verify that this image did indeed come from this device at this time on today.
Thank you, Geoff. Really amazing to see. Really interesting. Tell us about how latent fingerprint evidence is normally collected and the different techniques that investigators use right now and what problems that LIFT helps to solve.
Like I said, LIFT is fully integrated. There's very little things to fumble around with. You'll notice that there's an exposure time in the software, and that's really the only thing that you have to adjust. It's essentially the brightness setting that you have to adjust. There's no need to change filters out, change different light sources and things like this, which is often a part of many of the advanced techniques that are used today. These techniques can range anywhere from cumbersome laser and camera-based techniques where you kind of need 3 arms to position and optimize everything. It can take a long time. You're using basic SLR cameras with screw-on filters and things like this, which are not very efficient, and they get a lot of background. You'll notice that our system, one of the things that provides such good image quality is the near elimination of the background, even when we're imaging here in room light. That being said, I'm sorry. Can you remind me of your second part of the question?
Yeah, the different techniques that investigators use right now and what problems that LIFT helps to solve.
Exactly. Okay. So with these techniques, they're often time consuming. They can involve various chemicals. They can be even toxic, but generally very time consuming and difficult to get right. So LIFT then, by having all of this integrated, it is just fast, powerful, and very sensitive. So it matters very little what types of substrates, what types of materials that you're putting under it to image. It can image all types of materials fairly equally. And this allows a user to process a high amount of evidence in a short amount of time.
That sounds great. Are there any CSI teams or forensic labs currently using the LIFT device or working with fingerprint images taken with the device?
Yes. So while we're a relatively new startup, this is not a prototype device. This is a finished product. It's available for sale. We have systems that are in the field working. We have one system sold to a sheriff's department in Wisconsin, for example, and we have a number of other systems that people are lining up to purchase and requesting for next year's budget, for example.
What are your plans for getting LIFT into the hands of even more investigators out there?
I think the number one way that we can access our customers is through something called the International Association of Investigation, of investigators. And it's an international group, but they have a very strong national meeting once a year. But even more importantly, they have many regional meetings throughout the country. And with a device like this, it's really important that people get their hands on it to actually use it directly. Even use it with things that they've touched so that they understand what kind of fingerprints have been deposited. They can run a variety of different materials under it, and they get a sense of really the novel difference that this incorporated technology brings to the field. It's a new level of imaging than what people have seen before. And when you see it in person, you get to feel this and experience it.
When you demonstrate the LIFT device and you talk to investigators about your product, what kind of feedback are you getting? Do you get the sense that they understand the value of what C2PA technology provides, or is there still a lot of education that needs to happen about what that even is?
So the C2PA explanation is a fun bonus part of our typical demo at the trade show, right? So we do all the imaging, and the wow factor is obvious. It's very easy, it's very fast, and you get a high quality image right away. But the second part, the second wow factor, is the C2PA signing. The fact that in a courtroom you can point to this and say, okay, that is a verified image. That generally takes a little bit more explanation to uncover. So, for example, I think there's often a little bit of a misunderstanding if this technology is meant to prevent image tampering, and how does it work in that way? And so generally the clarification is, well, you're not locking an image to prevent it from tampering. What you're doing is you're verifying where that image came from. And in this particular application, that's extremely important in the courtroom because you're undergoing a lot of scrutiny to prove where that image came from. So by having this third-party verification tool, like I said in the beginning, that any jury, any judge, anywhere can use to verify that image came from that device at that time, can eliminate a lot of scrutiny, unnecessary scrutiny and distraction in a courtroom.
I agree. Thank you so much, Geoff. It's really exciting to see this practical use case for the C2PA standard in forensic evidence come to life with your Lift device. And I'm excited to see awareness and adoption continue to grow among investigators and among others in your field.
Thank you for having me. It was my pleasure.
Now, with a little bit of video editing magic, we're going to jump back in time. I'm going to invite Jen and Brandon back up to the stage, and we will continue with the Q&A portion of this event as it happened during the live event. I do have some more questions for you that we didn't get into before. So Jen and Brandon, what are some skills or knowledge that legal professionals should start building today to navigate challenges that AI might introduce in court in the future?
Well, I think everybody should kind of practice it, use it, experiment with it. If you haven't actually used AI, if you haven't manipulated a photograph to make somebody disappear in it or put someone into a photograph that wasn't there, it's going to be hard for you as an attorney to be able to even know what questions to be asking your witnesses about any particular piece of digital evidence. Obviously, we have forensic examiners that can teach us, but I think it definitely is helpful if you actually use it and experiment with it to be able to really understand it.
Yeah, I talk about this a lot, especially when we start training newer examiners. The more you know of how things are supposed to work, you'll be able to pick up on that outlier that much quicker. So the more you build that digital literacy on, no matter what it is, whether you're an attorney, an investigator, or an examiner, I think is important. I also think this is important where even faced with the best absolute technology threat of synthetic media, deepfakes, manipulation, editing on the latest devices, that foundational knowledge of good forensic practice, and when I say the stuff like Swiggy talks about, or a underlying understanding of how we properly extract data, how we properly analyze it, and have realistic expectations of that, will go a long way, especially as technology goes, because we have rules of evidence today. We have standards within the courtroom that they probably, Jan could argue about how much they need updating, but that have been around. We assess how evidence gets into the courtroom. Understanding those and how to apply that to technology, I think, is foundational in understanding what goes to authenticity, what goes to weight, and being able to address the most modern of technologies.
Mm-hmm. I see a comment in the Q&A. Oh, I just lost it. Where did it go? Yes, from David Notowitz. This is the comment more than a question, that if you think video is difficult, you should see how difficult it is to examine and evaluate audio. Brandon, can you tell us why it's so much more difficult to evaluate and examine audio?
So I'll say twofold, is that everything's a trade-off, right? So there's challenges and then there's benefits of audio. So traditionally in the past, we'll say in the past, a year or two, 3 years ago, most of the way that we actually authenticated video evidence, whether it be spliced or edited or changed, was through the audio track. However, what we do, especially within our, and I'll say, just to preface, our work and based upon our research at Magnet Forensics and our patented approach to media authentication, that also includes, as a side note, reading C2PA content credentials, and we'll start signing those manifests sometime next year, hopefully. But The approach for structural analysis, which we researched and we patented, is applied equally to the format, not necessarily audio versus video. So it works just as well on an MP4, AVI, M4A, or we're expanding to other audio formats as well. So that's a deterministic. That's not AI fighting AI. That, as we talked about before, Jenny brought up how the research says that deepfake detectors don't work in the wild. And I saw somebody ask for a reference. I could provide a whole bunch of references. I'm giving a talk later this week where I have them on my laptop of, research study after research study that says that, in the wild, deepfake detection doesn't work reliably, that, would be effectively used in court. However, we do have methods to do that in a deterministic manner, whether it be audio or video files. What scares me the most, though, is live audio. I will say that is an incredible challenge, one that I'm not going to sit here and say that we have a solution for, but it's also something that's different than recorded audio that we're trying to introduce in a courtroom. We're not going to go on to a podcast live in the middle of a courtroom in lower Nashville, in downtown Nashville, open up the speakers and say, okay, this is the audio, this is the evidence as it's playing live to you from across the country. It just doesn't happen that way. We fortunately in the legal sphere, we deal with recorded media. The audio, the live audio stuff is a significant challenge.
Mm-hmm. We have a question from Loic Forget. What are your thoughts of nudify apps and software? In a legal framework, are these legal? Jen, this might not be your area of expertise, but would you like to weigh in?
Oh, I was about to say, Brandon, I'm not familiar with that software, so if you could help me out, I might be legal context.
I'll say, I think we're talking about like these nudify apps right now that will take my image and use some generative AI and then insert my image on somebody that was likely in much better shape and produce a nude image of me. And I know that it's making a lot of headlines when it does happen. I'll say from a technical aspect, we are able to, at least within Magna Verify, able to discern pretty quickly whether that is original imagery or AI generated for use to understand. But that doesn't really address the issue of is it legal or not. I'll let Jan speak to that. From my experience, it really depends on where you are, and just another area where the law really hasn't caught up to the technology.
That's exactly correct. We had a news reporter locally that had this happen to her, and they hacked into all of her social media accounts and sent messages to all of her contacts, which, I mean, she was on one of our news stations, I think, for over a decade. So she had a ton of followers, and they create all manner of images of her onto other people's nude bodies. And she actually, I was at the legislature on another bill the day that she presented a bill to the legislature asking our Tennessee legislature to create a crime so that could be prosecuted, because we did not have anything where it was a criminal offense that could be prosecuted, which that is step one, to have it be a criminal offense. And then the step two, that even as I was listening to her, I was trying to figure out in my head of how do we prove who did it? Because it wasn't someone that they located, it was just being posted to her own social media accounts. So that's kind of the second step of how do we prove who the author is of that digital media.
That's a great point. That attribution is often the hardest thing in a criminal investigation and prosecution. And just to highlight something else really quick here, because I think it bears repeating. We saw when Jen talked about it before with the Vanderbilt rape case, that it wasn't just one single piece of digital media. It was, and it's often not just one single piece of media. Even in those nudify apps, it's the seizing and the lawful access to someone's cellular device where maybe it was created or transmitted. It's about the totality of the circumstances of the case. It's not just here's one JPEG or one PNG image. I need to solve this case with this. It's part of a larger, I'd say, investigative ecosystem. It's probably not the best way to say it, but that's what I got.
Mm-hmm. Does SWGD support continuous training for people handling digital evidence? Is there a certification framework tied to your standards?
So SWGD is concerned with producing digital evidence standards and best practices for like those practice standards I talked about. There is a standard or a best practice for training and education and knowledge, skills, and competencies within digital evidence, which is great, especially for there are the attorneys on the call who wants to evaluate, do I want to make sure that the person that is doing the work for me is demonstrating that they have demonstrated that competency or proficiency in performing that task. That's a great reference material for that. And then there's also a lot of great independent certifications within the digital forensics field, as well as vendor certifications. And if we have a second, just a quick shout out also. We talked a lot about SWGD and standards implementation and ways to implement it, and recognizing good certifications. And if anybody's using those standards, there's also another organization called the Organization for Scientific Area Committees. It's a NIST initiative. It's the OSAC, because we live in a land of acronyms here. It's easier to pronounce than SWGD, I'll tell you that. But if you are implementing SWGD standards, or if you look at it and you think it's something you're going to do in the future, I'd ask that you acknowledge that by going to an OSAC implementer survey, which I think we have linked on the SWGD website. If not, if you look at OSAC implementer survey, you can identify the standards that are, or best practices that you are using, or ones that you would consider in the future. That helps future development of standards and saying, well, this is important to the community. We need to develop more in this area, not just in digital forensics, but across all forensics.
Mm-hmm. Jan, for the legal community, how do legal experts stay ahead of advancements in AI? And hear about advancements and countermeasures such as the C2PA standard or detection techniques?
Well, I feel like, our legal experts are our forensic examiners, so it's not anything that's within, kind of from our perspective, it's making sure that the assistant district attorneys are meeting with the forensic examiners so that we're keeping up with what is the latest kind of efforts being made to be able to authenticate and determine whether or not something has been altered. So it's more of the forensic examiners educating us. I'm very blessed because I have really good relationships with forensic examiners that I've worked with and with Magnet Forensics, where I end up being exposed to a lot of training that most assistant DAs are not. And so part of, I think what's important is making sure that your kind of district attorneys association for your state or wherever you are, country, whatever it is, that they're doing that presentation and that education for the legal professionals. We obviously don't need the same level of training, but we definitely do need training so that we understand it better. The worst thing would be is if your assistant DA is not going to object to evidence or present evidence because they don't understand what the strength of the evidence that they have in their case.
Let's take a look at the Q&A window. I see a question from Andy Woodruff. Given that SORA 2 generates the content credential, I didn't see the CR mark like I have seen on LinkedIn. Is this just X not supporting credentials yet? Andy, that's a great question. X does not support credentials yet, but it's part of our work at the CAI to make sure that the display of content credentials becomes more widespread on social media, on publishers' platforms, and it's part of our work throughout the ecosystem to make content credentials and adoption of the C2PA standard more widespread. However, if you do have SORA 2 on your device, you can actually try this yourself. If you create a SORA 2 video and then drag that into Adobe Content Authenticity Inspect, or you can visit that using the URL inspect.cr, you'll see that content credential pop up. So it is there. It's just not as easy for people to find just yet.
I will tell you that is also a great concern of mine, is that as initiatives like, based on the great work CAI is doing in C2PA becomes more well-known, especially within the legal community and within across society, it's the expectation that things will have content credentials. And I think the biggest misconception that we see today is online social media platforms not providing the content credentials or any kind of independent media authentication prior to posting online. It affects us directly, take the disinformation argument out of it. It affects us directly when we're investigating crimes, serious crimes, or even trying to exonerate innocent people, because the process in which media is posted online, because face it, nowadays a critical incident happens, the first thing that happens, everybody takes out a cell phone, they start recording. Once that media gets created and gets changed and new media gets created for posting online to a social media site, it significantly reduces the ability to effectively authenticate it just by what's posted online. There are other methods through proper legal process to those online service providers to try to get closer to that original piece of evidence. But until our social media sites really start to get serious about independent authentication, which we've shown in our research they all can do prior to publishing, or supporting things like content credentials, it's not going to move the needle at all in helping us solve crimes or really believe what we see online for use in legal proceedings.
Mm-hmm. Yes, we're making progress, but there is lots of work to be done still. And part of that is education. Do you see any potential challenges in communicating more nuanced uses of AI in content to judges and juries? So for example, if your phone might use AI to straighten a tilted image, but that adjustment itself might not be a material change that takes away from something else in the image that substantiates your case.
Yeah. I'll hop in here for a second, only because, yeah, it absolutely is a concern, but it's not a new concern. Ever since we started compressing imagery on phones or on CCTV video, where it always becomes a question of, is that an artifact of compression, or is that a person walking down the street? Is that a New York Yankees insignia on their shirt, or is it something else based upon how that imagery was recorded and stored? AI adds a new dimension to that, is what I can understand, what I can't understand, and interpreting that content of that image. That's why, much like the things that you talked about and what Jan was talking about just now, is an understanding of and working with your forensic examiner to provide context to how images were created or how videos were created, to assist the trier of fact in understanding what they can and cannot use, or what can and cannot be believed. Let's be honest here, is that if I take the newest cell phone camera and I record my shirt, it's not going to change magnet forensic to Margot forensics. The technology has shown to be reliable enough, it's not going to do that. But oftentimes, we're not talking about the picture of me. We're talking about the picture of somebody across the street behind me that may not be the intended capture of that image. So that context is all the more important, all the more reason why we need to keep literacy up and keep our digital forensic examiners apart and our humans as part of this conversation as we get deeper into AI.
Jan, I'll give you this final question to close us off. What keeps you up at night, and what are you optimistic about?
Murderers keep me up at night, honestly. I feel like I feel confident that the forensic examiners are going to keep up with this, so that we are going to be able to authenticate our evidence. We're going to have actual evidence of the user that created the content to be able to explain it. It's something that's new. I think the biggest problem from a legal perspective is educating our judges, because if you think lawyers are behind the ball, having the judiciary and all of the judges really understand this, so that they don't have that kind of blanket, I don't understand this, it doesn't make sense, it sounds like magic, I'm not going to let it in my courtroom. I think that's the biggest hurdle that we're facing right now. I'm very confident that we'll be able to overcome everything else.
It's always nice to end on a note of positivity and optimism. Thank you, Jen. There are so many other great questions in the chat, but we are just about out of time. Thank you so much to all of our speakers for lending your expertise in this discussion. Thank you to everyone in the audience who joined us from wherever in the world you're dialing in from. Before we all log off, if you haven't already, I'll invite you all to consider joining the CAI to stay up to date on the latest developments in this movement for content provenance, and to hear about the next event like this one. If you're an implementer and you're looking to build with the C2PA standard into your product or your service, be sure to check out the CAI Discord to connect with others, to get guidance from the CAI team, to access educational resources. Santi will drop both of those links into the chat. Thank you all again so much. We'll see you next time.
Thanks, Jen.